Now, let us see some legal and compliance case studies. So, this presentation will explore the importance of legal and compliance case studies in the Ethereum ecosystem. We will examine real world examples of legal challenges and compliance issues encountered by businesses and individuals operating in the DeFi space. So, by studying these case studies, we aim to understand the legal complexities surrounding Ethereum and its applications. This knowledge is crucial for developing effective compliance strategies and mitigating potential risks. So, what are legal and compliance case studies? Legal and compliance case studies are in depth analysis of real world situations involving legal or regulatory challenges within the Ethereum ecosystem. These studies provide valuable insights into the complexities of navigating the evolving regulatory landscape for blockchain technology. So, examining case studies, including both successful and unsuccessful examples, can help organizations identify potential risks, develop effective compliance strategies, and understand the implications of various legal and regulatory frameworks. By analyzing these case studies, we can learn from past experiences and avoid making costly mistakes in the future. So again, we come to the DAO case. So the DAO was a groundbreaking experiment in blockchain technology and decentralized governance. It aimed to create a self-governing entity with the ability to allocate funds and manage investments through smart contracts. However, the DAO experienced a major security breach in June 2016, resulting in the loss of millions of dollars worth of Ethereum. The hack exposed significant vulnerabilities in smart contract security and raised concerns about the legal implications of decentralized organization. The regulatory response to the DAO hack highlighted the lack of established legal frameworks for blockchain technology. Governments and regulatory bodies struggled to classify and regulate DAOs, leading to uncertainty and ambiguity. The incident also had a profound impact on the Ethereum community, leading to a contentious hard fork that created Ethereum class as a separate blockchain. So, the lessons from the DAO case. So, the DAO case remains a landmark event in the history of Ethereum, offering invaluable lessons for the entire blockchain industry. The incident highlighted the critical need for robust contract security measures and comprehensive legal frameworks for decentralized organizations. The DAO case underscored the importance of legal preparedness and compliance in the blockchain space. It demonstrated that even decentralized entities can face significant legal and regulatory challenges. The incident also served as a catalyst for the development of improved smart contract auditing practices and the exploration of regulatory approaches to blockchain technology. So, SEC versus ICOs. The Securities and Exchange Commission has taken a strong stance on initial coin offerings, asserting that many ICOs constitute unregistered securities offerings. Notable cases include SEC versus Telegram and SEC versus Kick, where the SEC argued that digital tokens issued by these companies were securities subject to registration requirements. The SEC has issued guidelines for ICOs, emphasizing that digital tokens may be considered securities if they meet certain criteria, such as offering an investment opportunity, relying on the efforts of others, or promising a return on investment. So here are the lessons. So the SEC's actions against ICOs have emphasized the importance of regulatory compliance for token offerings. Businesses must carefully consider the legal classification of their tokens and comply with applicable security laws. Structuring compliant ICOs involves conducting through due diligence, obtaining necessary legal advice, and disclosing all relevant information to investors. The SEC scrutiny of ICOs has led to increased awareness of legal risks and the need for robust compliance frameworks. GDPR compliance. The General Data Protection Regulation is a comprehensive data privacy law implemented by the European Union. It applies to companies that process personal data of EU residents regardless of their location. GDPR compliance is essential for Ethereum applications that handle personal data of EU citizens. This includes applications that store, process, or share personal information through smart contracts or decentralized systems. Lessons from the GDPR compliance. GDPR compliance is critical for Ethereum applications that process personal data of EU residents. This regulation emphasizes the importance of data protection and user privacy, impacting how blockchain projects handle sensitive information. The DAO case highlighted the potential legal risks associated with handling personal data without proper safeguards. Businesses should adopt a proactive approach to GDPR compliance. This includes implementing data minimization practices, obtaining informed consent, and ensuring data security measures are in place. So here are some anti-money laundering cases. So anti-money laundering regulations are crucial for maintaining the integrity of financial systems. These regulations aim to prevent criminals from using financial systems to launder illicit proceeds such as drug trafficking or terrorism financing. AML regulations are complex and vary significantly across jurisdictions, presenting unique challenges for the decentralized finance space. Several high-profile cases have highlighted the importance of AML compliance within the cryptocurrency industry. Two notable examples include the BitMEX and BTC cases. In both instances, regulators alleged that these platforms facilitated money laundering activities. The BitMEX case in particular led to significant penalties and raised concerns about the adequacy of AML controls in the crypto space. So the lessons from AML cases are these regulations are crucial for maintaining the integrity of financial systems. AML compliance is essential for Ethereum applications involved in financial transactions or handling user funds. So implement in robust know your customer and customer due diligence measures to verify user identities and mitigate risks associated with money laundering activities. Ensure thorough transaction monitoring to detect suspicious activities and report them to the appropriate authorities. Adopt a comprehensive compliance framework that encompasses ongoing risk assessments, employee training, and regular audits to ensure compliance with AML regulations. CFTC and derivatives trading. The Commodity Futures Trading Commission is a US regulatory body overseeing futures and derivatives trading. The CFTC has assured jurisdiction over certain cryptocurrency derivatives products such as Bitcoin futures due to the potential to be used as a means to speculate on the price of underlying commodities. Several high-profile cases involving cryptocurrency derivatives platforms have brought CFTC scrutiny to the forefront. Notably, the CFTC pursued actions against BitMEX and Tether for alleged violations of derivatives trading regulations. These cases underscored the importance of legal compliance for platforms involved in cryptocurrency derivatives trading. So the lessons from the CFTC cases are that CFTC cases against cryptocurrency derivatives highlight the importance of regulatory compliance in this emerging sector. Platforms must ensure that they meet all applicable rules and regulations, including KYC and anti-money laundering requirements. Structuring compliant derivatives platforms requires careful consideration of legal and regulatory frameworks. Platforms should consult with legal professionals to understand their obligations and ensure they operate within the boundaries of the law. This includes clearly defining the legal status of the products and services and implementing robust compliance programs. Now let us look at OFAC sanctions and Ethereum. The Office of Foreign Assets Control is a US Treasury Department agency that administers and enforces economic sanctions based on US foreign policy and national security goals. OFAC sanctions can restrict financial transactions and prohibit dealings with designated individuals, entities, or countries. These restrictions apply to US persons as well as foreign entities that engage in transactions with US persons. Key cases involving OFAC sanctions and Ethereum include the US Treasury Department sanctioning of Tornado Cash, an Ethereum-based privacy tool, and the sanctioning of an Iranian cryptocurrency exchange for facilitating ransomware attacks. OFAC sanctions have significant implications for Ethereum applications and businesses. Ethereum developers and businesses must ensure they are not engaging in transactions within sanctioned entities or individuals. Compliance with OFAC sanctions is crucial for Ethereum projects and businesses to avoid legal penalties, reputational damage, and potential loss of access to US markets. So the lesson from this OFAC case is that the OFAC enforcement action emphasize the importance of compliance with the international sanctions. Ethereum projects must understand the risks and responsibilities associated with handling sanctioned funds. Implementing OFAC compliance in Ethereum applications requires proactive measures. Conducting due diligence on users, monitoring transactions, and establishing a robust compliance program are crucial steps. OFAC sanctions often target individuals or entities involved in illicit activities. Ethereum projects should implement screening mechanisms to identify and prevent interactions with sanctioned individuals or entities. These measures can involve using OFAC lists and conducting thorough transaction monitoring. Now, let us look at the consumer protection laws. So, consumer protection laws are designed to safeguard consumers against unfair, deceptive, or fraudulent business practices. They aim to ensure that consumers are treated fairly in the marketplace. These laws are crucial for the Ethereum ecosystem as it interacts with consumers through various applications and services. Key cases involving consumer protection laws in the cryptocurrency space include the investigation of Coinbase and Robinhood by the US Securities and Exchange Commission. These cases highlighted concerns regarding customer protection, market manipulation, and the potential for unfair trading practices. The lesson from these consumer protection cases are the need for platforms to provide clear and accurate information to users, protect user funds, and prevent unfair trading practices. Ensuring consumer protection compliance requires a proactive approach. This involves implementing robust KYC and AML procedures to verify user identities and mitigate risks. It is also critical to establish clear terms of service, disclose potential risks, and provide users with adequate support. So, let us look at intellectual property and blockchain. Intellectual property laws such as copyright, trademarks, and patents are essential for protecting the creations and innovations of individuals and companies. The decentralized nature of blockchain technology has introduced new challenges and opportunities related to IP protection. Blockchain offers a transparent and immutable ledger for recording IP ownership and transactions, which can help to enhance the security and enforceability of IP rights. Several high profile cases have highlighted the importance of IP laws in the blockchain space. Notably, the Ripple case involved allegations of copyright infringement related to XRP, Ripple's native cryptocurrency. Additionally, the BitTorrent case raised questions about the legality of using blockchain technology to distribute copyrighted content. The lessons from the IP cases. So, the IP enforcement actions in the Ethereum space highlight the importance of protecting intellectual property in the decentralized world. Ethereum developers and businesses need to be aware of IP laws and implement strategies to protect their creations and innovations. Key strategies for protecting IP on Ethereum include clearly defining ownership, registering trademarks and patents, and using blockchain technology to record ownership and transactions. These measures can help to deter infringement and provide evidence in case of disputes. So here are the best practices for legal and compliance. Proactive approach. So the adopt a proactive approach to legal and compliance matters. Conduct thorough due diligence on potential projects and partners. Implement robust compliance programs that cover KYC, EML, and OFAC sanctions. Regularly update your compliance procedures to align with evolving regulation. Second is the legal preparedness. Seek legal guidance from experienced professionals specializing in blockchain and cryptocurrency. Ensure that our projects and platforms are structured in compliance with relevant laws and regulations. Have a clear understanding of our legal obligations and liabilities. Third is the risk management. So, identify and mitigate potential legal and compliance risks. Implement effective risk management strategies, including comprehensive audits, transaction monitoring, and secure data storage. Develop procedures to handle and report any suspicious activities. So, this presentation explored the legal and compliance landscape within the Ethereum and blockchain ecosystem. We reviewed key case studies and lessons learned, covering topics such as the DAO case, SEC versus ICOs, GDPR compliance, AML cases, OFAC sanctions, consumer protection laws, and IP issues. We emphasize the importance of proactive legal and compliance practices, including thorough due diligence, robust compliance programs, legal preparedness, and risk management.